ratified and entered by this court. It is difficult to recount the sequence of events other than by reconstruction and inference, because neither counsel on this case now was in it at the time of these events. Suffice it to say, however, that a deal is a deal, and once made, it should control, even if a copy of the agreement can't be found until very late in the game. We argue that the court should give effect in full to the December 19th agreement and withdraw any order inconsistent with that. The record is clear as to contents of that document. The parties sealed their differences without counsel in December. At that time, the suit money was to belong to Gloria, the person who suffered the personal physical pain to get it. This stands to reason since Ernest was compensated for his consortium losses as a separate matter. 1 month later, Ernest took a contrary position and petitioned this court for an order against Gloria spending the money, alleging it was marital property. Gloria later spent approximately $20,000 pursuant to February 16, 1987, court order directing the parties to use their respective suit award money to save the marital properties from imminent foreclosure. This was all the money that remained of the $47,000. This, of course, is borne out by the Hong Kong testimony. But Ernest should not be heard to challenge what that $27,000 was spent on, since it was not earmarked, and an accountant would fly in the face of the as-is in the March 5th order. Mrs. Clay understands that unless this court implements the December 19th agreement, she may not go behind the March order regarding the divisions of the real estate as is. However, she respectfully requests, in light of the fact that Ernest changed his position regarding the suit award in an abrupt and offensive manner, reneging and forcing an agreement to yield her established rights on that settled point, and in light of the fact that she spent the funds on what was in February joint property pursuant court order, reimbursements from Ernest by half of the $20,000 she spent saving the property prior to March 5th is in her. Her compliance with the order of February 16th was in good faith. She could not have contemplated in February that the property which she was then keeping from foreclosure would in March be solely owned by Ernest, and that she would be without a claim for the money spent. In all fairness, Ernest has been unjustly enriched, especially considering that he did not spend his suit money on the marital property as ordered by the court. Consequently, Mrs. Clay also requests an offset in the amount of $4,100 that Ernest was ordered by the court in February to spend fending off foreclosure, but which order was not obeyed, his consortium money. 8. An accounting by Gloria Clay. Mr. Goldstein's argument for Mrs. Clay to provide an accounting for what she spent money on prior to March 5th, 1987, clearly and improperly goes behind the March 5th order, as this demand has unnecessarily complicated these proceedings and been in violation of an order of this court. Mr. Clay should be required to pay Gloria's attorney's fees. 9. Request for enforcement of the as-is provision as applied to 1516 Scottsdale. It is important to note that the December 19th agreement allocated this property to Gloria, along with the responsibility of repaying her mother the $10,000 debt on it. The corresponding provision held that Ernest should be responsible for whatever was owed to his mother. This provision is very revealing on the relative reality of the claims to reimbursement for the mothers, as seen by the two parties at arm's length in December, and it is a darn sight more objective and fair than what Ernest now contends for. Ernest Clay has admitted to the debt owed to Gloria's mother, Ruth Dunham, on the 1516 Scottsdale property. Additionally, his financial statement filed January 23, 1987, shows a $10,000 debt owed to Mrs. Dunham. He received that property, clearly worth far in excess of $10,000, under the March 5th agreement, and so received it with all its attendant liabilities, including the debt to Mrs. Dunham. This is straight from the order and cannot be disputed. Granted that this flies in the face of testimony in this case that the property in question was purchased from Mrs. Dunham with her down payment and is a trust for her retirement. It is not clear how this can ever be made to square with the allocations of that property to Mr. Clay, but a second quirk of logic, clearing him of the responsibility of reimbursing Mrs. Dunham, would defy common sense as well. Guanahani. Because the Guanahani property is threatened by foreclosure, any order providing that each party is to have a week per year is not practical or possible. To have such an order would in effect force the parties to pay and keep the property out of foreclosure. Gloria Clay is not in any position at this time to rescue the property. Mrs. Clay would be happy to award Mr. Clay the opportunity to save Guanahani if he could provide the approximately $22,000 needed to prevent foreclosure. In the event Mr. Clay is not interested or able to save the property, Gloria Clay respectfully requests this court order the properties to jointly sell the property and split any proceeds equally between them, or to award the property to Mr. Clay and grant some offsetting concession to her, such as one half of the $9,500 she has paid to date in an attempt to secure it. Lord's Laundry. The addendum to the March 5, 1987 order specifically provides in March 6, quote, that each party shall promptly turn over to the other all rents received for March 1987 tenancy pertaining to their respective buildings under the terms of this agreement. This is the only exception to the as-is provision in the same order. All rents includes the rents on Lord's laundry machines. Thus, Gloria is entitled to the rent money he collected from the machines on the property she received under the March 5th agreement. The record is replete with supporting evidence and calculations on this point. We are only talking approximately $195. Richard Joy bill. Mr. Joy was retained by both parties to assist them in the closing of certain property, the properties bought during the marriage. The remaining liability to Mr. Joy after the March 5th agreement pertaining to property Mr. Clay received under the agreement, and so was his responsibility. The manner in which Mr. Joy chose to apply payments from Mr. Clay to the debts for the various closing is irrelevant to a proper allocation of his bill. The fact that Mr. Joy's records reflect the liability pertaining to property belonging to Mr. Clay is the only salient feature of the payments. His office procedure of applying payments to the oldest bill means that the bill which he should have assumed as his as-is property is half paid with her funds. All payments on this bill prior to March 5th were with marital funds. The remaining bill of $893 is owed on 1503 and 1505, which Ernest took as is under the order of March 5th. He should pay the debt on his property. 13. Status of certain property. The status of the Chicago real estate on Michigan Avenue in Chicago is in dispute. Gloria has been consistent in all dealings in which that property was involved, while Ernest has not. Mr. Clay has changed his characterization of the property to suit his needs at particular moments. The property should favor the consistent position of Gloria regarding this matter and not allow Ernest to, in effect, perpetrate fraud on the institution which lent the Clays money on the basis that the property belonged to the Clays, not that it was some expectancy he might have someday. Moreover, the proceeds of the loan derived from using this property as a predicate for borrowing was marital, as was the original repayment source of funds. This should be a classic case for estoppel. Mr. Craig should now be estoppel to deny the ownership of this property is beneficially in him and is marital in nature. His oath on the financial affidavit would be a fraud otherwise. Mr. Craig has in the past taken a $2,400 income item on their joint income tax return for interest earned on certain CDs. This deduction implicitly creates a claim that the substance of the CDs was income to both Craigs, which means it was marital income. Mr. Craig has denied that the CDs in question are marital property. Inconsistently, Mr. Craig caused Gloria to be responsible for one half of the liability on an income as a result of the 1984 and 85 audits. She had to borrow to come up with the money to pay the back taxes on income generated on CDs he now says aren't theirs. Once again, Gloria should not be made to pay for Ernest's inconsistencies. The CDs in Chicago stand in his name and are subject to his withdrawal. They are conveniently his when that is to his advantage, and not when they can assume a status that will keep his right from having any of it and keep it in his family for future benefit to him. Another classic estoppel situation. The children's education. The oldest child, Shanta, will be going to college in August 1988. Due to Gloria's desperate financial situation, she is unable to contribute to Shanta's education this fall, nor is it likely that she will be capable of contributing in the near future.